Mr. Beat presents Supreme Court Briefs.
Globe, Arizona, June 8th, 1964. It all started with a prank call.
Is Seymour there? Last name, Butts.
Just a sec. Hey, is there a Butts here? Seymour Butts? Hey, everybody! I want to see more Butts!
No, not that one. Another one. The sheriff of Gila County arrested 15-year-old Jerry Gault after his neighbor, or a cook, accused him of being obscene to her on the telephone. The sheriff also arrested Jerry's friend, Ronald Lewis, whom Cook also accused of saying obscene stuff on the phone to her. At the time of the arrest, Jerry's parents were both at work, and the sheriff had made no effort to let them know about their son's arrest. When Jerry's mom got home from work, she had Jerry's older brother go looking for him. Only after Ronald's family notified the Gaults did they know that Jerry had been arrested. Jerry's mother rushed to the county jail to see him, but the sheriff did not let her take him home. The next morning, Judge Robert McGee of the Gila County Superior Court led Jerry's preliminary hearing. At the hearing, Jerry claimed that Ronald was the one who actually said all the vulgar stuff. All Jerry admitted to was dialing the number. Regardless, McGee wouldn't even set him free for a few days and gave Jerry's family no explanation for keeping him in custody for so long. Jerry got a formal hearing, once again led by Judge McGee, on June 15, 1964, but his parents were not allowed to attend. In fact, Jerry's accuser, or a cook, also didn't attend the hearing. Jerry did not get a lawyer to defend him. After Judge McGee found Jerry guilty of making, quote, lewd phone calls, he ordered him to a juvenile detention center for 6 years. In other words, he wouldn't be free until he was 21 years old, man. It's worth noting that if an adult had been convicted of the exact same crime, their maximum punishment only would have been a $50 fine and 2 months in jail. Jerry's parents filed a petition for a writ of habeas corpus, claiming that their son was not given a fair trial. They filed the petition with the Supreme Court of Arizona to try to get Jerry freed. However, the Arizona Supreme Court referred the case back to Judge McGee, who, you guessed it, denied the petition, claiming that Jerry had committed a misdemeanor by using, quote, vulgar, abusive, or obscene language while in the presence or hearing of any woman or child. Jerry's parents appealed his conviction to the Arizona Supreme Court, but it agreed with McGee and upheld the conviction. Jerry's parents appealed again, this time to the Supreme Court, and they agreed to hear oral arguments on December 6, 1966. Sure, it was easy for the court to see how Jerry's Fifth and Sixth Amendment rights were being trampled on, but the broader question was whether or not the Constitution actually protected juveniles, or those under 18 years old, in the same way it protected adults. Specifically, the court needed to figure out if the way that Gault was committed to a juvenile detention center was constitutional under the Due Process Clause of the 14th Amendment. Well, the court said no. On May 15, 1967, it announced it had sided with Gault. It was 8-1. The proceedings of Arizona's juvenile court were unconstitutional. Justice Abe Fortas, a well-known advocate for children's rights, wrote the majority opinion. He argued that the 14th Amendment's Due Process Clause had indeed said that juveniles have the same rights as adults in the criminal justice system. More specifically, Jerry Gault, as well as all juveniles, for that matter, had, number 1, the right to remain silent. Number 2, the right to know the charges against them. Number 3, the right to a lawyer. Number 4, the right to have their guilt proven beyond a reasonable doubt. Number 5, the right to confront and cross-examine witnesses. And finally, number 6, the right to appeal a judge's decision. The court found that Arizona's juvenile court system had failed at protecting all 6 of these rights, and they ordered Gault set free. In re Gault was a huge case because it expanded 14th Amendment protections to juvenile defendants. Kids must get the same rights as adults, dadgummit. The case dramatically changed the entire juvenile system across the country. After this case, judges could no longer randomly and unfairly give out punishments at juvenile delinquency proceedings. For the first time in American history, the court clearly said kids deserve constitutional protections too. I'll see you for the next Supreme Court case, jury. Here's my approximately monthly shout outs to everyone who donates to me on Patreon at least $15 or more each month, starting with my biggest donors. Thank you to Bill Dowd, Alicia Solberg, Andrew B., Anthony Beckett, Austin Ciros, Corey Ryman, Douglas Martin, Derek Williams, Dr. Paul J. Lilly, Elaine Warwick, Empty Machine, Fletch Fick, Isabel, Isaiah Warfield, Jeremy Dunham, Joe Cook, Michael Cortez, Neo R14, Nick Everett, Osbers Gaming, Defender of Communism, Pat Iapicca, Patrick Stewart, Sammy, Samuel Striz, Saul Goodman 1917, Sean Connett, Society's Basement, Adam Christians, Alex Villasenor, Andrew Snyder, Grant Hughes, Ian Driscoll, Jack L., Jacob Birnbaum, Joel Serrano Lozada, KZ210QB, Oliver E., Naderade, Raquel Jones, Stacy, Steve Bryan, Steve Issen, Thomas Oppenheim, Warren Girard, Waterfort, and Zachary F. Parker. Thank you to all my Patreon supporters, and thank you for watching.